It's 1 o'clock, so we're going to get started again. Mr. Jordy, you can continue.
Thank you, Your Honor. Mr. Powell, we took a little break. Are you ready to go, sir?
I am.
Okay, and you understand you're still under oath as you were before?
I do.
All right, thank you. I think we left off, we were talking a little bit about taxes. Are you aware, sir, if there's any moratorium, like a 10-year moratorium, where you do not have to pay taxes during construction, and then for a period of 10 years on personal property?
I am not familiar with the specifics of North Dakota tax law. No.
All right. And in terms of the taxes you had mentioned you were going to pay, were there real property taxes on land owned that you believe you're going to be paying?
Again, Mr. Jordy, I'm not the tax expert.
All right, that's fine. I want to touch on the tiling just a little bit. Is it true that it would be your preference that the pipeline would be located in ground that didn't have tiling?
No.
All right. For a landowner who doesn't currently have tiling, and let's say your project is approved, and then later in the future they want to put tiling in, and realize now that the cost of that is more significant because of the workarounds of the existing pipeline, is part of Summit's commitment to pay for that increased cost of the landowner?
I think it's prudent upon the landowner. I don't think it's prudent upon the landowner to work with us now. And as Mr. Ellingson said, that we are working with all landowners that want to discuss tile, future plans, current tile. And we're open to those conversations to potentially put in headers around the pipeline that would allow a landowner to install tile in the future, or some type of accommodation like that, but it would be specific to each landowner.
Okay, and I appreciate that answer. I just want to make sure we're on the same page. Does that mean, and tell me if I'm wrong or right, but does that mean if a landowner, for instance, wouldn't choose to engage in a conversation now, pipeline gets approved, and then they're like, well, hey, we'd like to put in tiling, is Summit committed to paying for the increase in cost?
We're not going to penalize a landowner because we haven't signed an easement with them, or that may come down the line. If their willingness to work with Summit is dependent upon us receiving a permit to construct from the PSC, we'll have that same conversation we would with them then that we will now. And again, we'll take it on a case-by-case basis with the landowner. But as soon as they let us know what their plans are, the more quickly we can accommodate, because as you can appreciate, we have construction contractors under contract now that we're planning how to execute this project. And any change late in the game makes a difference. I'm not saying we won't accommodate. We will or won't accommodate. But the conversation won't change. It's just preferential to have it sooner than later.
But is that another way of saying that the company's not willing to go onto record and say, yes, if our pipeline is located there and that has increased the landowner's cost of tiling after the fact, are you not willing to commit to paying that difference due to the location of your pipeline?
You're asking me to speculate because I don't know what their cost is. And as you know, we've contracted with Ellingson. We know generally what their costs are. And we've agreed that if there's existing tile in place, we'll accommodate the repair or replacement regardless of cost. But I'd have to take each future case or each future situation on a case-by-case basis.
All right. Moving to page 11, section 2.23 of your application, it's entitled Capacity. We've discussed the 18 million metric tons per annum, and your application states that 0.54 of those million metric tons per annum will originate from the Charleston plant. Is that correct?
That's based on Tharaldson's current production profile. That's correct.
All right. And if we did the math of dividing 0.54 into the 18 million, would you agree with me that's roughly 3% of the capacity would be the Tharaldson plant?
You can do that math. I would suggest that currently we have about 9 million tons under contract, and so that 500,000 tons per annum prorated. If they're also in other plants, as we reduce the carbon intensity, help them reduce their carbon intensity score, they may make expansions to push more production from their facility. So I can't speculate what their production will look like in 2 years, 3 years, or 5 years. Currently, it's 500,000 tons roughly per year against the 9 million that we have under contract.
When we were talking about, from your standpoint, what some of the benefits, potential benefits might be, I think you were making the statement that you believe the price of corn or the price that an ethanol plant could pay a farmer for its corn, its grain, could go up if your project is put in place. Were you making that connection or no?
I didn't mean to infer that it could go up. I mean to infer that it's my understanding, and again, I'm not an agriculture expert, but our parent company has been farming for 3 decades. It's my understanding that with the inception of ethanol plants, that has helped buoy, one factor that's helped buoy the commodity prices for corn.
Okay, but I just want to be clear. You're not inferring to the commission that, but for this project. So if this project doesn't go, then the existing farmers were going to get a lower corn price. You're not trying to make that connection, are you?
I am not.
For the ground that you seek, is the permanent right-of-way, is that 50 foot?
Yes.
And then for the temporary easement, is that easement limited to 2 years, or do you have a time limitation on that?
The temporary easement or workspace is limited until the project is complete. That particular tract or parcel of property has been reclaimed and to the satisfaction of requirements set forth by the PSC if we receive a permit and the landowner.
Okay, so in terms of using the word temporary or temporary workspace, that, to be fair, is kind of a roving deadline based upon completion, which can be delayed for weather, acts of God, labor shortages, or other things, correct?
It could be. Obviously, we want to get in and get out as quickly as possible to minimize the disruption to the landowner.
And the access easement, is it true that, or do you believe that allows you to enter the 4 corners of a given parcel anywhere that's expedient for you to access the permanent easement?
No.
Do you believe that the access easement has limitations, and if so, can you tell me what they are?
Well, there's temporary access and there's permanent access. And those are stipulated with each easement agreement for each parcel of land. And typically, we want to stay on the right-of-way. So that includes the permanent and temporary workspace. And then access to that right-of-way, whether temporary or permanent, is agreed to with each landowner.
Okay, but for the permanent access easement, is it your understanding that you are not confined to ingress and egress on the 50-foot permanent easement? The access easement allows you to access the permanent easement from whichever direction is most convenient.
Well, that's clearly stipulated in the easement agreement. So if it's a road or it's an access through a gate, that'll be clearly stipulated in each easement agreement. So we have no flexibility there without permission from the landowner.
All right, so you believe that a landowner then, in I guess negotiation or conversation with you, can limit the portion of their property that is potentially affected via access?
The landowner has all the control of this discussion, but obviously we're not going to say. Obviously, we would not enter into enter an agreement with a landowner if we couldn't access the property to construct. And we'll do that in the most minimally disruptive fashion. But we have to have access to construct.
And when you say the landowner's in control, you're of course aware that if you condemn the landowner, there is no renegotiation of the easement terms, right?
I wasn't referring to condemnation.
All right. Well, when you say, sir, the landowner's in control, I guess just help me. What does that mean? Because that's opposite of my understanding.
You were talking about easement agreements, and we're having a discussion with a landowner at this point in the project. They can dictate where the access is, just like depending on where they've had an opportunity to tell us where they prefer to have the pipeline on their property.
And section 2.213 on page 16 is entitled Landowner Notification, Easement, Acquisition and Compensation. Why did you believe it was important for you to put some description about easement and acquisition and compensation in your application?
I don't know the relevance of that, the way that sentence is worded. But, I mean, I think you're aware of the compensation structure.
Now, the project schedule, this is section 3 on page 17. Would you agree the project schedule, you're not on track to complete right-of-way acquisition in October of 2023?
Well, our current schedule doesn't necessarily dictate we start construction in October of 2023.
Okay. And so when it says the MCE project will be built in 2023 and 2024, is it fair to say at this point in the time of year that you will not be starting construction if approved in 2023?
I think it's to be determined. So if, obviously we have to have the ability to construct in all 5 states. We prefer to have the ability to construct in all 5 states. But we don't necessarily have to start construction simultaneously in all 5 states. So if we receive a permit from the PSC in North Dakota, and we have land acquired, and we have our other permits, local permits, and we choose to start construction, we may. And if we don't, we may choose to defer that until 24.
If only North Dakota PSC was to approve your application, would you still construct the project?
I don't think that's going to be the case, so that's speculation that I don't feel I should respond to.
Okay, well, a moment ago I'm just following up on your answer, you had said that you prefer to have approvals in all 5 states, so that leads me to infer that there is a possibility where you would move forward if you didn't have all 5 states. Can you clarify that?
That's an option for the company.
It's an option you've considered.
No, I mean, when you're executing a project of this size and scale, Mr. Jordy, my job is to look at all contingency scenarios.
You've got a section on project alternatives, and there's a no action alternative, and the no action alternative is essentially the status quo, correct?
I don't remember the definition.
Okay. Well, I mean, no action basically meaning you don't do this project and we are where we are. Is that fair?
Well, there's always a risk that we don't receive a permit from the PSC in North Dakota.
And then you talk about system alternatives, and you tell the commission that you don't believe, well, let me just read this and ask if you agree with this. It says, quote, "These existing pipelines do not provide a system that could be utilized for transportation of CO2 from industrial sources in Iowa, Minnesota, Nebraska, South Dakota, and North Dakota." Do you agree with that?
Which pipelines are you referring to?
The existing CO2 pipeline infrastructure in North Dakota.
Correct.
And again, by you including all the other states, that is your way of saying that if all the states' CO2 are going to be shipped through and get into North Dakota, that the existing CO2 pipelines could not handle that, correct?
That's correct.
But the existing CO2 pipelines could handle the 0.54 million metric tons per year of the Tharaldson plant.
That's assuming that those pipelines, I'm assuming the one you're referring to is on the east side of Bismarck. It's assuming that you could lay a pipeline to interconnect with that, and that company would be willing to then acquire pore space and accommodate Tharaldson.
But wouldn't you agree if Tharaldson would hook up with that pipeline as opposed to coming down into South Dakota, then back up into North Dakota and then to the sequestration point, that would affect less landowners and be a shorter route?
Mr. Jordy, my job is to manage this project, and we've looked at what we feel is the optimal route in North Dakota, make sure that we're routing around all constraints that we've mentioned in the previous two hearings, and accommodating landowners to be able to reach an agreement with them. We feel this is the optimal route.
Would you agree at 12 million capacity per metric ton, and I realize you're going to 18, but at 12 million per annum, with the 45Q tax credits, that would lead to over $1 billion a year in tax credits to you?
Again, I'm not going to speak to the commercial arrangements we have with our ethanol partners.
Okay, well, if we just do the maths are on 12 million times an 85 metric ton tax credit, you wouldn't disagree that's over $1 billion a year every year to you?
That's the math, but you said to us. So that's an assumption that Summit would reap 100% of the benefit of that tax credit. I'm just saying that I'm not as familiar with our commercial obligations, our commercial agreements with these plants.
But do you understand, forget about the agreements with the plants, do you understand that it's the entity that owns the capture equipment that receives the 45Q tax credits?
You know,
That may be one requirement, yes.
And Summit or a related Summit company will be owning the capture equipment, right?
With the existing plants, that's correct.
Now you have a transportation alternatives, and you say that CO2 transportation by tanker truck or rail tankers is technically feasible, but is better suited to the movement of small quantities of gas. Do you stand by that?
Yes.
And so you agree that CO2, to the extent that anyone decides it should be transported, could be transported by truck?
I think if the state wants to subject, the public to an exorbitant amount of tanker trucks on the highway to move 12 million tons of CO2, it's feasible.
And in terms of the benefits, when you talk about taxes and economic benefits, you would agree that if it's trucked and every one of those trucks is buying fuel within North Dakota, is paying wheel tax within the state of North Dakota, has a truck driver that's employed and contracted, that would generate far more of an economic benefit than your pipeline?
Well, I don't know that to be true, but I also think that hypothetical may be challenged, because I'm sure you understand the truck shortage in this country at this period of time, and in getting that many tanker trucks and deploy them in North Dakota, I think would be an extreme challenge.
You understand that the 45Q tax credits expire in 12 years. Is that your understanding?
It's my understanding.
So what would be the plan after you're no longer able to secure tax credits for this project?
Well, I think once we've generated enough income to pay back our debt associated with the initial construction, we feel comfortable that our cash flow will sustain the business beyond 12 years without the tax credit.
And so what would the source of cash flow be but for the tax credit?
Again, we're getting into the commercial agreements, arrangements with the plants, and I'm not the right person to speak to those.
Who would be the right person to speak to that?
Our chief commercial officer.
And that person's name is?
Jim Paroli.
you've got a section of where you've identified 69 areas. You call them isolated finds. And it says that are resources that do not possess sufficient data yield. Is that another way of saying you don't have enough information to know if those are problem areas, or can you explain that?
I don't remember that specific section.
All right. In terms of, you're familiar with avoidance areas, is that correct?
Yes.
And I noticed in your Iowa filings that sorghum, where sorghum's planted, is a avoidance area. Do you have any knowledge why that would be?
Again, I'm not the expert. I think Mr. Schmidt testified in Bismarck on our behalf, and he's our environmental expert.
Okay. Do you recollect, or in any of your conversations, of why sorghum would be a crop to avoid for us?
I'm gonna object. This has to do with Iowa and not North Dakota.
I agree.
In terms of avoidance areas or avoidance crops, are there any crops that shouldn't be planted, or you prefer not to be planted in North Dakota, where a CO2 pipeline would be located?
Not to my knowledge.
And in terms of SCS Carbon Transport, you are contracting out, obviously the tiling work, the construction, the environmental analysis. You basically don't have people on staff doing that. You are relying on third-party contractors to assist with that investigation and data gathering. Is that fair?
Well, I think like most major project organizations, whether you're with a large company like Energy Transfer or a smaller company like ours, we have subject matter experts and professionals on staff, and we utilize consultants to support that staff.
In terms of, on page 37, it's required permits and approvals. Have you, meaning the company, obtained any approvals that you need from the federal government, either the Army Corps or the U.S. Fish and Wildlife yet?
Those are in progress.
And then what about North Dakota state-specific permits? Have you obtained any of the North Dakota state-specific permits that are required for this project?
You're referring to the PSC?
The PSC, the Department of Environmental Quality, the State Historic Preservation Office, and then the Department of Water Resources.
We have not.
And what about from the county floodplain administrators, those floodplain development permits? Do you have any of those?
Specifically, I don't remember, Mr. Jordan. As I mentioned earlier, we are in the process of applying for the local permits now because, as you probably know, they have a shorter timeline.
A shorter timeline, meaning an expiration date on them, or?
No, for approval.
Okay, the faster approval process.
Right.
Okay. Now, the emergency management, I know that's been a topic of concern. Has Summit met with all the volunteer firefighters, those departments, the permanent departments, and EMS along the proposed route?
I don't know that it's been a concern. However, we do have a gentleman on our staff who's been on our staff for over a year, who is an expert in emergency response, and he's a former firefighter, and he has met with officials when available in all 82 counties, including 10 counties in North Dakota. And that's at this point, typically, at this point in the project, typically emergency planning professionals. As we get closer to the project, then yes, he'll meet with first responders, and then we have an obligation to train those responders, make sure that we understand what resource needs they have, with specifically to equipment, and then we'll actually conduct drills before we place the pipeline in operation, so we're compliant with PHMSA guidelines.
And your emergency management plan, it's got a watermark draft on it, but the one that you submitted as part of your application in the appendix, is that your current version of that plan?
Those plans evolve. And so those plans evolve as we get more information, as we acquire more right away, as we understand more clearly the issues along the pipeline route, and as we have conversations with those first responders and emergency planning professionals.
will you be providing electric vehicles to all of the local first responders, knowing that if there is a CO2 rupture, internal combustion engines may not work properly?
Well, I think what's important is that we train first responders that the primary response is evacuation. Is to contain the area, so it's not to drive a vehicle into the area where a plume may exist. So electric vehicles, I don't think would be of value, but what would be of value are CO2 sensors, fresh air packs, things of that nature that will protect first responders in the unlikely event that we had a release.
How many permanent employees dedicated to emergency response will be physically located in the state of North Dakota should this be approved and constructed?
So at this time, the preliminary plan, and I say preliminary because again, we've got to make sure that once we acquire 100% of the right of way, we understand the full pipeline route and the risk. We understand the conditions from the PSC. So right now, the preliminary plan is 35 employees, and most of those employees will be trained in emergency response.
The 35 employees, though, will they be? Where would they be located? I mean, give me an idea. What are these people doing?
Well, they're at various points along the pipeline. So along the full pipeline, we'll have a damage prevention group, and they'll patrol the pipeline. And so we'll have folks stationed in Bismarck. We'll have folks stationed in the sequestration site. The pump station won't be manned 24/7, but it will have personnel there periodically. So we'll have people that are stationed along the full route of the pipeline, not permanently, but periodically.
Okay, and of the 35 persons, not every one of those 35 is exclusively dedicated to any type of emergency management. Is that fair?
It's fair.
And is it also fair that you rely upon the local EMS, emergency management response, firefighters, police, to be the first responders in case of any leak, rupture, spill?
Well, like many other pipelines in operation in North Dakota and other states, they typically are part of the first response, or they are first responders. The difference here, Mr. Jordy, is CO2 is not flammable or combustible. So at least we're not worried about an ignition source, an explosion or a fire. So the response is different. We're also not worried about overland flow like with crude oil, like with refined products. So the response is different.
You're aware, obviously, aren't you, that CO2 is odorless, colorless, and unlike oil, crude that we could see, you may not even know that it's in the vicinity.
It is odorless and colorless, but if there is a release of CO2, you will likely see a plume that is white in color because that's moisture. It's entraining the CO2.
Would you agree to, like natural gas, add an odorant or an ingredient so that if there was a release, it would be immediately obvious to any person?
We think in our investigation to this point that adding an odorant may be more risky, and that how it will react with the CO2 and the composition of the CO2, even though it's nitrogen and oxygen, other than the 98% or so purity of the CO2 or purity of the CO2. So how does that impact corrosion, the development of corrosion, etc. So we're still conducting that analysis, but as you know, there are over 5,000 miles of CO2 pipeline in this country. I don't think any of them are odorized at this point. And then secondly, even most natural gas pipelines, at least transmission lines, are not odorized. So there may be some residential interconnects that are odorized, but most transmission lines are not.
So my question was, would you be willing to add an odorant which would help with the detection and help with the safety aspect?
I would question whether it would help with detection because, again, in the unlikely event of a release, the plume would be sudden and it would dissipate depending on environmental conditions, dissipate very, very quickly. So at this point, I would not add an odorant to the stream.
And the person or persons at Summit who are in charge of giving you the data on that, who would those persons be?
There are chemical engineers.
All right, and is that a contracted firm?
They are.
And what's the name of that firm?
Primeric.
Trimeric?
Primeric.
All right, thank you. In terms of the plume modeling or dispersion modeling, the commission, I believe, asked for that at Gwinner. Have you turned that over to them yet?
Well, we're willing to turn it over. I understand there's a discussion with yourself about the ability to turn that over.
Okay. It is, what's the particular reason why you're not sharing that model publicly?
Objection. I think it calls for, I don't know if you call it a legal conclusion, but he's getting into issues that Mr. Jordy and I, and Mr. Baki and I are discussing, and I don't think it's appropriate for this witness to be discussing this in an open forum. Discussing this between one another and trying to resolve it.
Well, that assumes that there's even a valid objection to not producing it. My question is, well, why don't they produce it? Why doesn't the company produce it? And what's the reason?
I feel like we've gone over this at both other hearings, that this is protected information by PHMSA and others, and that my understanding is Summit is willing to produce it if they're granted trade secret or confidentiality protection of that information. So, and I know it's not necessarily come up, and I think may discuss it at the end of the hearing, but there's been discussions about filing a motion for that type of protection, that information. So I think that issue has already been discussed, and I think we can move on.
Well, I appreciate that. I would like just to get, I'm trying to make a record here from the company. Is that the company's statement that they believe this is protected trade secret, yes or no, and then I'll move on.
Well, as PHMSA characterizes pipelines, they're critical infrastructure. And so there are things like dispersant modeling that should not be shared because of that security risk.
Okay, so is it your position that no one would know that these are risky unless they saw a dispersion model analysis?
No.
Okay, so where's the big secret? We all know these are risky, right?
He's basically ignoring the instruction.
Yeah, we need to move on. We've discussed this at other hearings, and I think we're going to have further discussions when the motion is filed. So I just don't think it's a good use of our time today.
Section 7.4 is entitled Use of Citizen Coordinating Committees, and your application on page 44 says, quote, the applicant does not anticipate the use of a citizen coordinating committee, end quote. Why is that?
Personally, I'm not familiar with what that committee would do or how it would support the project.
Well, would you be open to having a group of citizens like the folks here and participating in these hearings, having a committee and sharing their concerns and working with a dedicated person from your firm on a weekly, monthly basis?
But we've had numerous public meetings. We've had numerous meetings with individual landowners, so it's my position that landowners have had input into this project for quite some time, specifically around routing, specifically around the depth of pipe. So in my opinion, that committee is not necessary because we give every landowner that's willing to talk with us an opportunity to provide input.
And what do you base that on, sir? With all due respect, you're not a land agent, you're not in the field, and so
I am in the field, Mr. Jordan.
Okay, and when last did you talk to a landowner that hasn't already signed an easement?
2 weeks ago.
All right, and why hadn't that person signed an easement yet?
They did sign an easement.
Okay, and do you think that if the landowners if they would just listen to you, then there would be no opposition?
I didn't say that. What I'm saying is we have over 4,200 landowners on this project. And so obviously I can't speak with all of them, but our organization, our staff, both contract staff and Summit badge staff has spent a lot of time meeting with landowners and welcome the opportunity. Can we meet with all 4,200 on a regular basis? We cannot. But when we have the opportunity and when someone's expressed an interest, and we do that. I would also say that by and large, we think our agents are qualified to have those general conversations. And then if there's a question specific to drain tower, specific to construction practices, or something of that nature, then they bring in a subject matter expert to talk with the landowner.
Earlier, when I was asking you about pressures, you had stated that the lower range of the pressure and the higher range of the pressure, that if we dropped below a lower range, there wouldn't be corrosion because of the dehydration process that the CO2 goes through. Is that a fair statement?
Well, I'm assuming my assumption is that you think that water may be entrained in the CO2 molecule and that may fall out at lower pressures. When that's the pipeline, other than in the unlikely event of a release, it's going to stay under the minimum pressure to keep it in denser supercritical state.
But a little bit ago, you said that there really isn't a risk because there will be a white cloud because of the moisture in the CO2. So do you dehydrate it and there's no moisture, or is there moisture?
No, I didn't say there wasn't a risk. If there is a release, then the CO2 obviously loses pressure, becomes, it changes state of its phase, and then you may see the moisture and the cloud.
You've got a section about structures, residences, schools, places of business within 500 foot of the pipeline. Where did you get that 500 foot as the delineating amount of what to report?
As Commissioner Chrisman corrected me a couple of hearings ago, that's state law.
All right, very good. And the 500 feet, when we're talking about a 300 foot corridor, how have you reported the 500 feet? Is it 500 feet from the outer limits of the corridor on each side, or is it 500 feet from the ideal main line, which would be 150 feet from the 300 max corridor?
It's from the nearest point of the inhabitable dwelling to the edge of the corridor.
Okay. If the landowner has a residence within that area and does not get a waiver, are you going to be forced to reroute?
Yes.
In terms of agricultural production, you say you'll restore the construction right of way to its preconditioned contours to the, quote, extent reasonably practical, end quote. And it's true, sir, that Summit exclusively determines what reasonably practical is.
Well, I think that's typical with all pipeline projects. But again, as I mentioned earlier, we're entering into a long-term relationship with landowners, and we're also bound by whatever conditions the Public Service Commission place on our permit. So we fully intend to restore the land, again, as I said, as found or better condition.
And I appreciate that's your intent, but at the end of the day, you, Summit, as the applicant, has the power to determine as reasonably practical whether it's possible or not. That's your determination, right?
Well, I don't think we have the discretion to determine whether it's practical. It's something we have to do.
But if it gets to a point where you have satisfied yourself as Summit that looks good to me and landowner doesn't, what's the process now?
Well, we'll work with the landowner to try to ensure that they agree that the property has been returned and the right-of-way has been returned to the previous condition.
And if you can't reach an agreement, what's the plan?
Well, as I said, we're going to have a long-term relationship with landowners, and I don't want an unhappy landowner if we can prevent it. As I said, we've got over 4,000 landowners, so I'm not going to sit here and say that we won't have a landowner that isn't unhappy at the end of it, but we'll do everything we can, reasonable and practical, to make sure that they're satisfied with the property when we leave.
Are you familiar with the term man camps?
I am.
And what is that?
That's a temporary housing facility can be for anything, but in this case, an infrastructure project, a linear infrastructure project. If there's not accommodation within a certain area, then there could be a man camp, an RV park, something like that established.
Would you agree that historically the data has shown that where man camps are located, the resources and draw on law enforcement has seen an uptick as opposed to prior to the man camp being there?
We have no intention of having man camps on this project.
How do you plan to house all the construction workers and the associated contractors throughout all the phases?
Well, we've done a labor study and we've looked at accommodations in and around hunting season especially, and when those accommodations are available, and worked with the contractors to ensure that they don't need temporary man camps.
In order to make good on that, that would limit your construction season, correct?
No.
If it's attached to the hunting season, wouldn't that limit?
But it depends, Mr. Jordy, on the size of the spread, the number of spreads, the sequence of construction activities. There's a lot of factors involved, but we've been working with our contractors for several months on an execution plan, and they feel comfortable that they can accommodate their personnel without man camps, and we agree with their assessment.
Did you used to work for British Petroleum?
I did.
And that's not noted on your qualifications and experience. Why is that?
I think that's my qualification experience is general, but I spent 15 years with BP.
Were you there during the Deepwater Horizon?
I was.
And you're familiar with that, was essentially a vertical pipeline?
Well, that's not a correct characterization, but it was a blowout preventer that failed.
Okay, and so part of the time when you were there
on a well, by the way, it's a little different than a pipeline, a linear pipeline.
Okay, but so you were there, and you then have experience, obviously, with man-made pipelines failing, welds breaking, and catastrophic conditions occurring.
Objection, relevance.
Can you address relevance?
Well, yeah. Do you want to approve a catastrophically risky project like this? I mean,
I can answer, Judge.
Go ahead.
So there are literally thousands of those vertical pipelines, as you characterize them, Mr. Jordy, on the western side of the state. And to my knowledge, and I've done a lot of work on the western side of the state, but not in the last 6 or 7 years, that there's been catastrophic failures. And you're probably aware of the very, very strong safety record of pipelines being operated in this country.
Okay, you would agree with me that if you're the person, if you're the family or the farm where there is a release, an exposure, it doesn't matter if 99.9% of the rest of it worked fine. You would agree with that, right?
Yeah, I would agree. If you're in an area where there is a catastrophic failure, yes, that would be correct.
And have you looked into the Satartia, Mississippi findings of PHMSA and the failures and getting to the lack of training for the emergency responders? And have you Summit have developed a plan of best practices based on those failures?
Yes, so there are 5 failures that PHMSA outlined. And in fact, I was in Satartia, Mississippi last Monday. So I am very familiar with the report. We've ensured that, one, if Denbury, the operator, had followed PHMSA requirements, that failure may have still happened, but they would have identified that geohazard and hopefully mitigated that risk. And then if they would have addressed that potential risk in their dispersant modeling and their response and their preparedness and their notification, that may have had an impact.
Is it Summit's plan, like Denbury, to declare bankruptcy if you have a catastrophic spill here in North Dakota?
I'm not familiar with Denbury's balance sheet, but we don't plan on having a catastrophic failure.
I understand that, and I hope you don't, but isn't that an option to declare bankruptcy?
That's speculation that I'm not going to address.
All right, just give me a moment. I am winding down, Your Honor. I'm ready to start back up, gentlemen, whenever you're. Sir, is it true that if your pipeline is located on a particular, say, farmer's land, that you can withhold certain permissions of how they use their land or how they interact or develop or not develop over the easement, permanent easement area?
We do have restrictions over the 50-foot permanent easement that are discussed with the landowner during the easement negotiation process.
Will you allow tiling under the pipeline, assuming it gets built?
We would, and in many instances, and I'll extend this to every landowner, as Mr. Ellingson mentioned earlier, even if you're digging on your own land, you should call 811 so that we realize that you're digging in and around the pipeline, and I even offer to do that excavation around our pipeline for them to accommodate installation of their tile.
And that offer that's not found in an easement or a document, or when does that offer get made? When does the landowner?
We put that in easements, so that's discussion with the landowner. So we try to be as accommodating as we can within reason.
In terms of indemnification and landowner risk, is it true that landowners' negligence could still expose them to risk?
Action calls for a legal conclusion.
I agree.
Okay. Do you have an understanding of that?
I have an understanding of what our indemnification says.
Okay. What do you believe it means?
An objection, you can answer it in terms of your experience, but not as a legal conclusion or as that of a lawyer.
Okay. My understanding is unless the landowner intentionally damages the pipeline, by intentionally, that's their intent. Not if a piece of equipment sinks and sits on the pipeline and damages it, not if they accidentally strike the pipeline, even though we implore them to call 811 or let us notify us when they're digging in around the pipeline, they are indemnified.
Just to be clear, that's your understanding?
Yes.
And in terms of crop loss, you've been offering 3 years of kind of prepay for crop loss. What's the process if there's yield loss beyond those 3 years?
So again, if the landowner can demonstrate that yield loss is atypical when compared to the yield on either side of the pipeline right away, Summit will compensate the landowner for that yield loss.
Is it true that you can sell or assign or transfer any or all of your rights in this pipeline at any time without the state, without permission by the PSC?
Objection, ask and answer.
He can answer if he knows. I don't recall what his answer was, if he did answer it.
Well, again, you're asking me to speculate. If it's in CO2 service, we could sell the pipeline, as you mentioned earlier, but whoever acquires the pipeline is bound by the same conditions of the easement specific to each landowner. If it's not in CO2 service, the PSC has to then, they would have to, whoever the potential owner of the pipeline system would have to go back to the PSC and petition or apply for a change in service.
Why are you seeking a 99-year easement if the tax credits only go out 12 years?
Again, we think we're We're building a pipeline system that's a viable business that will be in service well beyond the 12-year tax credit. And as I mentioned earlier, the cash flow forecast supports the business and the operating expense beyond the 12-year period and the potential expiration of the tax credit.
Is it true that without the tax credit, this project wouldn't be possible to get started?
It is true that the tax credit or the value of the tax credit is part of the economic support for the project.
A significant support.
It's support for the project.
All right. I don't have anything further at this time, Your Honor.
Right. Commissioner Chrisman, any questions?
Yes, Your Honor.
If a landowner wants to tile their land and the pipeline is there, and you need to send people out to monitor that process when they're working near, is that at a cost to the tiling company or to the landowner, or is that something that Summit would need to do as the owner of the CO2 line?
No, Commissioner Chrisman, it's like any other pipeline or any other potential crossing of our pipeline. Responsibility is on us to go out and oversee that. So it would be at no cost to the landowner.
What do you think is, I'm trying to determine whether an order from us should have a minimum amount of distance between hydrocarbon pipeline and tiling pipelines. It's been discussed that a foot is optimal, but do you have a minimum in mind?
Well, in my experience, Commissioner, that I built pipelines in many different services, 12 inches is the standard. I think it's different from, it could be determined to be different with a tile, for instance, or a tile line. But again, we'd have to take in consideration the corrosion aspect of it and the cathodic protection aspect of it. But 12 inches, I think, is a minimum. But as I said before, there may be a situation where we could entertain something less. We just don't want the tile itself, even if it's not cased and it's just the polymer HDPE material sitting right on the pipeline.
I need you to go to the map book. The big one on the bottom.
What's that? This one.
And I don't know how much you've looked at this lately, but they're in groups. It's not paged all the way through, so about at least 3/4 of the way to the back are a bunch of maps that are down in this area of the state. And I'm looking at map number 1 of 29. It's by the Theraldson plant, if that helps you find it quicker.
Okay, I think I have it.
Well, actually, skip one page ahead. I think it works out better if you go to 2 to the next page.
Okay.
So, you see on the right side of the page, so it'll be just to the east of the pipeline, there's the hashed land that says Red Lake Nation Treaty Lands. And there's more off to the west, and some to the north, some to the southwest. A number of these pages have that, and I'm not really familiar with that. I don't know what that is and if it's anything we need to deal with on this. So can you describe to me what the Red Lake Nation's treaty lands are?
Commissioner, I'll have to get back to you. I'm not going to give you a very informative answer, but I can get back to you.
I'm okay with a delay on it, but since they're highlighted on here, I'm trying to figure out if they're meaningful for us.
And Commissioner, if I recall correctly, and perhaps Mr. Shook can respond as well, but I think that was a question that was addressed by the commission staff and we responded. So there should be something in the file, but I'm happy to look for that and forward to the commission counsel and provide you a copy.
Now that you say that, I do agree that has been responded to, but I've forgotten the answer, but I can find it. So
Unfortunately, I have too, sir. Sorry. I forgot the answer
the
to it.
response has been provided. I'm sorry, but I was on this page for a different reason though. So while you have it open, up toward the top to the right. So we're talking about maybe a little more than a half a mile from the Tharaldson plant. On the east side of the proposed pipeline corridor is a long, narrow, looks like a building that runs north and south, or a lot or something that looks very close. It would certainly look to me like it's less than 500 feet. I don't know what that is. I don't know if it's occupied structure.
I'll find out, sir. I can't discern from the picture, but I know our team has done a fairly thorough analysis of all structures, and you brought that up in previous hearings. I know we've got all that information, but I'll make a note of this
I need
page.
this one identified, please. And I don't even remember. Oh, I do remember. I marked it here. Way back, now I'm in about the middle of the book, page 1 of 3, and it's where the proposal would start just south of town here, a couple miles. And maybe even the map isn't so important on this question, but what is the depth? I assume you're boring underneath the Red River, not open trenching, correct? Correct. And what's the depth of that bore?
And I can get the answer specifically, Commissioner, but typically we're 30 to 40 feet below the mud line. You know, it depends on the extent in high water or the wetland area on either side, where our entrance and exit is, and what our radius is, and what we've done scour analysis on all these waterways. So we're looking at, you know, the long-term risk that potentially could be involved with scour, and then we go back on either side, an adequate distance, and then we're making sure that we're a significant distance above the mud line, the existing mud line, to mitigate any risk. I can get you for this. If you want, I can get you the information for all the drills, but I can get you for that specific one if you're.
I would like that, and I think it's important because I think sometimes like in North Dakota, the Geological Survey, I don't know what Minnesota has for something comparable. Sometimes I've even seen one example where they wanted it shallower than what our original proposal was because it was in a better strata.
Yeah, depends on if there's silt and other things where you could potentially you'd lose the hole in rock and sure.
I'd like to know what the proposed depth is.
Okay.
For. And lastly, and the details of it are something that I'd prefer to get into in Clinton or Bismarck later. But I want to make sure that this isn't being dropped at Gwinner. I asked you to prepare an assessment, you know, based on some of the concerns that have been brought out about the route going north of Bismarck, about looking at going south of Bismarck, south of the University of Mary somewhere. Are you working on that?
Yes, diligently working on that. So we'll work with Mr. Bender to get that information and in what form we provide that information. But yes, we are diligently working on it.
Okay, I have no other questions.
Commissioner Haugen Hoffert?
Thank you. I'm glad Mr. Crispin brought that up on some of our requests. It seems like some of our requests are getting very delayed, and we would like some of this information so when we go to hearings, we can have that and be able to ask questions on that. So I hope some of this information can be expedited for our upcoming hearings. So thank you for working on that. I'm kind of stuck in the, hopefully I can get this. We're asking to approve a pipeline, and when we were talking about the liquid going through the pipeline, the question was asked, who owns that? And no answer was given. Can we get an answer to that?
You want me to respond to that?
Someone.
Yeah, I think it goes to an issue of common carrier status.
Okay.
And that's the reason for not necessarily disclosing it at this level. The issue of whether a pipeline is a common carrier pipeline is really not an issue for the commission in terms of making a determination as to whether it should be cited under the Citing Act in North Dakota. It is an issue with respect to eminent domain, and it is an issue with respect to determining whether the company has a right to survey the property. That issue is currently before the district court in the state of North Dakota. Judge Narum out of the, I believe, Sargent County has that matter before him. And it's also a matter that's before two district courts in the state of South Dakota. In the state of South Dakota, there's protective orders that have been put into place because of some of the commercial information that was filed discovered in that case. And it's very proprietary and confidential. So our concern is that we have a protective order in South Dakota. We have a protective order in North Dakota with respect to that commercial information. And now we have an intervener here requesting the information. I can talk with my client, Commissioner, and perhaps that's something that we can provide to the commission if it's put under seal. I'd have to talk with my client about that first.
Okay. And I respect the answer. Thank you, Mr. Bender. My intent was always to be respectful of confidential information, but when I look at the liquid going through there, I'm looking at it from, if approved, maybe some of the requests that we might have in our order, and I would definitely work with our council and staff on that. Some of the safety measures, we've talked about emergency management and response. So that was my intent on asking some of this question. So I'd work with Mr. Pellman on getting more of that information to address some of these concerns to make the decision most appropriate and a safe decision.
Yeah, and thank you, Commissioner. And if Mr. Pelham can provide me with, some of the information on why that's important in terms of the order, I think that'll be helpful in me talking with my client and then making a decision on whether they want to provide that in a confidential status.
Okay. And I'll be doing so. Okay. That's all the questions I have. Thank you.
Thank you.
Mr. Dawson?
Judge Hogan, when you separate the pipeline from the drainage pipe, you do that only with dirt, or are there other materials that you could use to separate them?
Yeah, Mr. Dawson, there are various methods. They make plastic type structures, HDPE type structures that sit on the pipe and provide a kind of a fixed distance. As Mr. Ellingson testified to earlier, we prefer to use sandbags, which allow some flexibility for the pipe and the drain pipe has to maintain a gradient. But that way, it's not so rigid that it would damage the drain pipe per se. So there are various methods. So we're relying on Ellingson, who are the experts in this area, to guide us in that direction.
I was picturing in my head that somebody would shovel on about 12 inches and then just lay the pipe over the top, but it's more complex.
It is.
I had a question about one of the maps. It was number 2 of 29 at the back. It starts with Cass County. So it starts with the ethanol plant. Then the second map after that.
I believe I have it.
Okay. There's a purple line that goes over a green line. I was just trying to understand that down at the bottom third of the page, because it appears to me that a purple line is an access road and a green is a wetland. And can you explain that? Why they seem over each other?
Yeah, so I think as Mr. Smith testified in Bismarck, I mean, there, depending on the wetland, we can construct in and around or on it. So in this case, the access road is on the wetland. My assumption, and it could be incorrect, my assumption is that's a temporary access.
And then you don't have to really look at the map, but on number 14, there's Richland County Waterfowl Production Area, and the pipeline crosses that. Are there any special considerations or permits or anything related to that waterfowl production area?
Yeah, Mr. Dawson, I don't know off the top of my head, but there typically are. I mean, we can research a specific area for you, but yeah, there typically are.
When you look at the map, it kind of goes out of its way to go through the production area if you're drawing a straight line. And I was just curious, kind of like the Red Lakes Nation treaty lands. It's an anomaly. But I have no further questions.
Thank you.
Mr. Dawson, I don't know if this answers your question, but there is a legend on the map, and I think the legend suggests that the line you were referring to is an access road.
The access road, there's a little green right below it. If you look,
Yeah, the access road crosses the wetland area.
And
I follow your question now. I apologize.
All right.
He has good eyesight.
Mr. Bender, any redirect?
No redirect.
Mr. Pelham, any other questions? Mr. Jordy?
Yes. In terms of your exclusive right, is it true, sir, that you have the exclusive right to affix or annex or essentially put the pipeline to the ownership of the landowner?
I don't understand the question.
Okay, so do you have the exclusive right to decide if you want to abandon the pipeline in place and leave it under the landowner's ground, correct?
I'm going to object. This is beyond the scope of the direct examination or the other questions that were asked by council and the commissioners.
I agree. I'll allow him to answer though if he knows.
No.
No, you don't know, or no, that's an incorrect statement.
No.
Which one?
No, I don't know.
Okay. Picking up on the commissioner's question, is it true? It's either you, Summit, or the ethanol plant that owns the CO2 once it gets into the pipeline. So what's the big mystery as between who is it? Why won't you simply answer that as directed earlier by the hearing officer?
I mean, I've made my objection on that, and I've explained, and I've instructed him not to answer. And you can do what you're talking about doing, and that's fine. But I'm instructed not to answer that question either.
All right. Well, there's been no showing that this is confidential. There's been no showing whatsoever that his objection has any basis other than obstructing this hearing. And it is very relevant of who's transferring the product and who to direct conditions to, and a whole host of other reasons. And it doesn't matter if it may also have to do with 20 other things. We're not talking about that.
And I disagree with you, and you can continue to ask the question. I'm going to continue instructing him not to answer.
Okay.
Well, and I think that there's been a request from one of the commissioners for that information. Mr. Bender said talk with his client, and we have 2 more hearings to address this, and maybe we can do it through filings as well. So I think we need to move on. I think it's been addressed.
Well, I guess just forgive me. I was just curious that they have the unilateral power to not give requested information to the PSC, and they haven't made a showing that it's confidential in any way. I just find that, I mean, dumbfounding.
Your Honor, he's already indicated what he's gonna do. Should just move forward and we'll deal with it later.
Well, okay. I don't know what the big secret is, but okay. Is it true that the entity who owns this CO2 has the right to claim the tax credit?
I don't know if that's correct or not.
Is it true that the ethanol plants can only claim a 45Z tax credit and they're not available to claim the 45Q tax credit?
Objection, Your Honor, relevance. What's this got to do with this?
Well, and I think Mr. Powell's already said he's not familiar with the tax provisions and not an accountant, so I think we just need to move on.
Okay, all right. Who at your newly formed company would have that information?
As I stated previously, our chief commercial officer would have more information specific to that than I would.
Will you make him available at the Bismarck hearing?
I mean, I'm going to defer to Mr. Bender.
You asking?
I mean, do I have to send a subpoena for him? Would you just bring him there?
Talk to my client.
Okay, all right. I'll send a subpoena. Okay, nothing further. Thank you.
Are there any other questions from the commissioners? All right, thank you, Mr. Powell.
Thank you.